West San Gabriel. How are you today? Good, thank you. Thank you for attending today. You have a treat. This is a very educational class today. Okay, let me get started with a little safety issues, or not safety issues, but our exits are to the right, to the left. And please, at this moment, silence your cell phones, please. And please hold all your questions till the end. Once she's done, you can come up to the podium, form a line, and ask your questions. Okay, today's speaker, April Verlato, a lifelong resident of Arcadia. April is a local small business owner, community leader, and devoted mother of two. A product of local schools, April attended Highland Oaks Elementary, Foothill Junior High in Arcadia. She graduated from Westridge School for Girls and then went on to get her Bachelor of Arts degree in Political Science from UCLA. She obtained her Juris Doctorate degree from Southwestern School of Law in downtown Los Angeles. Shortly thereafter, April took over her family law practice and has remained an active member of the city's small business community ever since. She serves on an executive board at the PTA, her children's school, for many years. April was elected to Arcadia City Council in 2016 and served as mayor from April 2019, May to 2020. She was reelected to a second term in Arcadia City Council in April of 2020. April is a founding member of Downtown Arcadia Improvement Association, where she has worked to rejuvenate life into the city center. She has worked on the committees that organize the Patriotic Festival and Fireworks, Halloween Haunt, and Holiday Fair. April has been at the forefront of promoting and virtually of the city's business community and working to ensure that Arcadia continues to achieve her growth. April is a resident of Arcadia Highlands, where she lives with her husband of 13 years and her two children. Let's give a warm applause to April Verlato.
Hi. Good morning, everyone. Thanks so much for being here today. I really appreciate it. I hope that you walk away learning something a little bit new about transfers of real property on death, right? So this is kind of expected to be just a little primer, just to give you a hint of an idea of when you should be referring clients or yourself to an attorney to determine how to transfer the property after someone's passed away. As you can see on my first slide, I now notice I've missed a zero on the 2025. It is February 26, 2025. But I'm happy and delighted to be here as your guest today, hopefully giving you some exciting information. To me, it's exciting. I don't know about the rest of you, but exciting information about how we transfer real property when someone passes away. So first and foremost, golden rule of probate, you cannot take your property with you when you pass away. So you have to have some sort of plan for transferring assets at death. Pretty much anything over $184,500 in value in an estate for somebody who's passed away is going to go to probate or court unless you have some other means of that transfer. Oops. Okay. So if you have assets in excess of $184,500 and you have a will or you don't have a will, those assets are going to need to be transferred through court. Okay, that's what's probate. Probate means going to court and transferring those assets. It can take a bit of time, right? Typically a year, sometimes 2 years, depending. The quickest I've been able to get through probate is about 9 months. That's a really quick time turnaround. Occasionally I can do that. You're going to have a lot of paperwork to file. It really is. You've got to have an attorney to know everything that needs to be filed. And all of your information then for the decedent becomes public because now the court has to review everything. So you have to give them a list of all the assets that are in the decedent's estate. So that's one of the downsides of probate and having to go through court to transfer your assets. Okay, so when you're doing a will, this is going to be a legal document that contains the instructions as to what should be done with your assets after you pass away. The thing is about a will, it doesn't really become a valid document until you pass away, right? We can't use it while you're still alive. Also, a will can be handwritten or typed. It does not have to be typed. It does not have to be prepared by an attorney. However, of course, as an attorney, I'm going to recommend if you're going to do a will, have an attorney prepare it for you. All right, so let's say you have to go to probate and transfer your property out of court. This is just a sample of how much it's going to cost in attorney fees, right? So this is on a $500,000 house. Again, these are estimates, but this is just to give you an idea of what those costs are going to be. Attorney fees are scaled. They're based on the value of the assets before you take out expenses. So if you have a $500,000 house with a $400,000 mortgage, the attorney fees are going to be based on the $500,000 value, not the $100,000 in equity. Okay. So the attorney fee is going to be 4% of the first 100,000, 3% of the second 100,000, and 2% over that 200,000 up to $1 million. After $1 million, it's 1%. Okay, so and then you can figure it out from there. But this is just an example of a $500,000 house. Actually, when I first started and prepared these slides years and years ago, 500,000 used to be like the average home price. Not anymore. But this is just to give you an idea of how much the attorney fees would be. There's filing fees. They're usually now running about $1,000 and even more now. I'm seeing it's just going up and up. The courts are finding all different kinds of ways to charge more and more money. So it's probably a little bit more than $1,000. Publication, it can be anywhere from $500 to $1,000. That's where your probate proceeding has to go into the newspaper and be published as to that proceeding taking place. Probate referee is basically an appraiser. It's a court-specific list of people who are qualified to give valuation of property. And so they're the ones who will determine the valuation of the real property. They're completely independent. The attorney doesn't pick them. The court picks them, and they come up with the value of the property. Then you might need a bond. A bond is basically like what I try to explain to people is it's like an insurance policy, making sure that the personal representative of the estate, which is going to be either your administrator or your executor under probate, that they don't take off with all the money. So a bond company will issue a bond or an insurance policy ensuring that personal representative up to a certain dollar amount that's set by the court that's based on the value of the assets to make sure that that personal representative doesn't take off with all the assets. Okay, so I know you guys all have heard a lot about trusts. To me, that is the preferred method of transfer on death of assets, especially your real property, right? What you're going to find is that a trust is an excellent tool for managing assets for people who own real property. So that way, when something happens to you, you own real property. Let's say you no longer have capacity to manage your financial affairs. Someone can step in, take over, and manage all of the assets. It's operative immediately, meaning the minute you sign it, it's a legal, valid, enforceable document, and it has instructions for both what to do with your assets while you're alive and then what to do when you pass away. This also helps you to avoid probate unless somebody wants to contest the trust, and then you're right back in court. It does, what's nice is it gives a lot more flexibility in how to manage your assets if something should happen to you. So there's a lot more room for instructions. So a lot of times you'll have clients, I'm sure, that say, I don't want to leave my assets to my children, they're minors. I want something that says we're going to hold all this real estate and manage it and use the rents to take care of my kids. Well, that's something you can very easily do in a trust. And we're able to get those instructions directly from the parent or directly from the client to be able to write it up exactly how they want it. You can also hold assets. You can say like, oh, I want to allow my daughter to live in my house after I die until my daughter dies. And then I want to distribute the house to my grandchildren. So you can create those kinds of instructions very easily in a trust. It takes it out of court, and then everything is being managed by a trustee. It's all on paper, very easy. You don't have to go to court for it. And just again, these are just primer, like the bare minimum of what happens during a trust administration of real property after someone passes away. So first and foremost, you have to give notice of the trust administration to all beneficiaries and heirs at law. That means you should go to an attorney because, again, there's statutory requirements of what that notice of trust administration is going to have. You're going to need a property appraisal. I call it a trust certificate here, but it's basically a certification of trust. The successor trustee has to sign off that they are the successor trustee under penalty of perjury. They use that document in order to have control over assets. Sometimes you'll need an affidavit of death of trustee. So if the property is in the name of the trust, it's really in the name of the trustee. So you'll see that property gets titled, you know, John Doe as trustee of the John Doe Trust dated January 1st, 1991 or whatever. So you'll see that that's how it's titled, so that when John Doe passes away and Jane Doe is going to come in and take over as successor trustee, you file what's called an affidavit of death of trustee. That affidavit changes title into the successor trustee's name so that they then have signing authority for listing agreements, to sell the property, to rent the property, those kinds of things. So you want to make sure, again, you go to an attorney if you're in this situation, to make sure that the person who's signing your agreements, your listing agreements, or your the deeds selling the property, because it'll come up once you go to sell the property and you go to get title insurance. Your title companies are going to check the chain of title, and they're going to look to see who's the person that really holds title to that property. Okay. And you want to make sure it matches up with who you have signing your deeds and signing your listing agreements. You want to make sure that property is held and distribution to the beneficiaries doesn't occur until all the expenses have been paid off of the trust and tax returns are filed and everybody signs off on receipts that they've received their distributions. And maybe, and sometimes you get waivers and releases of any of the liability of the trustees. So it can take about 6 months to go through that process with real property. And depending on whether or not the beneficiaries want to sell the house, or the trustee wants to sell the house, or just transfer title directly over to the beneficiaries. You can do either depending on what the instructions are in the trust. Okay, so just again, some real basic differences between a will and a trust. A will, it's not going to become effective until death. It's going to require probate, and there's going to be a lot of costs in court. Where a trust, it becomes effective immediately upon signing. It does not require probate, and there's going to be minimal legal costs. Most attorneys are just going to charge hourly fees on preparing the notice of administration, getting the tax returns prepared, preparing a certification of the trust, and preparing the distributions, receipts, waivers, and releases. So typically what I see, if there's only one property and we're just transferring to beneficiaries and we've sold the property, it runs about $1,500, maybe $2,000 in costs. It's very minimal. So that's why, again, that's why living trusts are usually a better option. A lot of savings in costs. And so your clients may be asking you, which do I need? Do I need a will or a trust? These are some of the things you want to consider when determining whether or not you're going to go in and get a will or a trust. And if you see there over under the trust side, it says just about anyone who owns a home or other real property, right? So if somebody owns real property, most of the time I'm recommending that they get a trust and do it that way. You'll see on the back end, as we keep going through the slides, why I recommend, regardless of how much the value is, right? So sometimes people have vacant land and they say, oh, my vacant land's only worth $10,000. Do I need a trust? Yes, you'll see why when we get to the end here. What happens with those vacant land properties when you don't have a trust. So, but you can use a will whenever you don't have real property. You just have limited assets, anything under $184,500. And remember, that number will change from year to year, depending on what the state legislature decides. So it hasn't been changed in a while. So it should be up to, this is since 2022, I believe, is the last time they changed that threshold, the 184. So it goes up ever so often to keep up with inflation. Let's see. Next slide. Some other ways of transferring outside of a trust or a will is you're going to hold property in joint tenancy, right? So I know a lot of you, you help married couples buy property and then they purchase the property in joint tenancy. That's great. Surviving spouse will get the property, right? But what I see a lot of times is families want to add their child as a joint tenant. And I don't recommend that. And I'll tell you why. I'm in litigation right now where the son is trying to kick his mom out of the house because she added him on as joint tenant. And she thought, my son will never, ever want that half of the house. Well, guess what? Got married, he had kids, he needs half a house. So mom is now facing the threat of being kicked out of the house that she thought she was doing a good thing by putting his name on title to the house so that when she died, he would just automatically get it. Anyway, he didn't want to wait till she died. So don't do joint tenancy if you can avoid it. It's, married couples, fine. But anybody else, I don't really recommend it because when you add somebody on as a joint tenant to your deed, you are saying as of today, the day you sign that deed, adding that person on as a joint tenant, they literally have a interest, a property ownership interest, and can demand that that property be given to them and not wait until you die. But if you are going to have your clients, if your clients do want to use a joint tenancy to hold title, make sure that it states so on the deed. It will only go in joint tenancy if it's expressly stated there. Otherwise, it's what's called tenancy in common. Tenancy in common is just co-ownership, and you put the percentages, how much percentage, and everybody knows up front, and it's a current ownership interest. And then once if you do hold title in joint tenancy, someone passes away, you need to file what's called an affidavit of death of joint tenant. Again, recommend that you go see an attorney, have them prepare it, make sure it gets filed correctly so that you have good, clean title. Because what happens when you go to sell that property and you go to get title insurance is checking title chain. And if it's got any glitches, you're trying to go back and find dead people in order to clean up any of those chain of title errors. So, and believe me, I've had that happen too. And it's very hard to get dead people to sign off on things. So Transfer on death. This is a deed that the legislature well, to me, just put in. I think it was about 3 or maybe it's probably like 5 years ago now. I never use these. However, you might see some of these deeds come along. This is supposed to fix the joint tenancy problem that I talked about earlier. This is a deed where you can state that you are the owner, but when you die, it's to go to, and you can list the specific beneficiary. So we didn't have these available for a long time in the state of California. Now they are available. However, I still do not like these. I still would lean towards doing trusts over a transfer on death deed, because again, you're going to leave it to somebody at your death and it just goes straight flat out. You can't have any other instructions. And if something happens to you, you're still alive, but you're not able to manage your finances. This transfer on death deed does not allow the beneficiary to come in and manage that asset, that piece of real property. They have to wait until you die to be able to have any access or power over it. So it's not preferred, because if something happens and the owner no longer can manage their finances and we need to bring in somebody else, you're going to do a conservatorship if you don't have a trust set up with all the assets being managed easily through a succession in a trust, a successor trustee. Hegstat petition. Sometimes you might come across clients who say, don't worry, my parents, they had a trust. It's cool. I can sell the property. And you go to look at the property title and it's still in the parents' names as husband and wife, joint tenants. It's not transferred into a trust. But the child does have a trust document that shows a successor trustee and identifies property that says it's supposed to, transfer on death. With that, you can do a summary petition in probate, right? It's a summary probate petition. I call it Hegstat because that's the name of the case that came up with this method of transferring property into the trust. It usually only takes about 60 days, one court appearance. Costs are still about $4,000, which includes the court filing fees. And when there's, let's see, and so you just file this Hegstat petition and you get a court order that says the real property was meant to be in the trust. And then it gets titled in the trust. And what's important is your title insurance companies will accept that when they go to insure title. All right, spousal property petition. This is going to be another way of claiming title to property when what I see all the time happening is one spouse has purchased property, real property, either before marriage or during marriage, but only took it in their name, or they inherited property from a parent. And so they took title only in their name as a married person, but separate property. The surviving spouse can file what's called a spousal property petition. Again, this is like a summary probate petition. It goes quickly. It's usually one court appearance, unless somebody objects to it and says that's not really separate property or it's not community property. So a surviving spouse can claim real property through this summary proceeding. Again, it's going to take maybe 2-3 months to do. And you get a court order that basically confirms that real property belongs to the surviving spouse. And if it's separate property, and it truly is separate property, and there's children involved, the surviving spouse will only be able to claim their percentage of the separate property. So with separate property, and this is why we need to know a little bit about community property laws in the state of California, separate property goes 50% to a surviving spouse, 50% to the decedent's family, other than the surviving spouse, right? The heirs, what we call the heirs at law, unless there's 2 or more children. So if the If the decedent, who is holding separate property, dies with just one child, and has a surviving spouse, 50% to the surviving spouse, 50% to the child. If a decedent had a surviving spouse and 2 or more children, it's 1/3 to the surviving spouse, 2/3 to the children, regardless of how many there are. So if there's 5 kids, they divide up the 2/3 equally. Okay. So the spouse, the surviving spouse, can file this spousal property petition and claim their 1/3 or their 50% and go through court and get it in 2 to 3 months. The children, they're going to, or heirs at law, sometimes it's, siblings or parents that are claiming the other half of the property when there's no children, no issues surviving the decedent. Then they still have to go through probate because they are not a surviving spouse. They have to probate their half or their 2/3. And then that causes also a lot of problems. And again, you can avoid these problems with a trust that clearly states who's to get the property, especially with separate property. We can do what's called a separate property trust for those people who own property and they're married, but they've acquired that property outside of marriage. Okay. Oh, and again, costs are roughly, $4,000, including court filing fees. And actually, probably with the prices of eggs, I need to increase that price to 4,500 because eggs are expensive. Okay. There's a little there, so there are some little exceptions that can get you through transfers of real property outside of a formal probate proceeding. That's if your real property is less than, and it's basically less than 184,500. That's pretty much going to be your vacant lands out in the middle of nowhere. And actually, like if this is in LA County, if it's got houses around it, you're still looking at $1 million in property value. But if you got this property somewhere out in the middle of nowhere, you might actually get below the 184,500. No, and I think I think more and more like even mobile homes, right? I think even those are now going up in price so much that they're even over 184, like for mobile. See, yeah. Well, I mean, but I still see from time to time some mobile homes that are worth less than 184. What you also have to check while we're on this about some real property of small value, and I'm talking about mobile homes. Mobile homes sometimes are considered real property and have deeds. Sometimes they are considered just like a vehicle and have a registry, like a DMV registry, and they have what's called a pink slip. So although you as a real estate agent can sell it and represent them in the sale, it's like selling a car. It's just a pink slip. So you won't need to do anything through probate court if your mobile home is worth less than 184,500. You can do what's called an affidavit of small estate and transfer that property if they have the pink slip. Getting a duplicate pink slip is always difficult, though. I would recommend going to an attorney. So, and can you write your question down? We're going to try to, well, I'm almost done, and then we'll start asking questions for questions at the end. All right. Okay, so if your property is less than, if the value is less than 61,500, and again, that number is going to change from year to year depending on what the state legislature decides is the threshold amount. Just a few years ago, it was at 55,000. Now it's at 61,500. This is basically what I call an over-the-counter process. So you still go to court, but it's literally like file a paper, they stamp it, you get the paper, and you go and record it. You do have to wait, and I didn't put this in here, you have to wait 6 months after date of death to be able to do this process. But it's an over-the-counter by affidavit. It's a judicial council form. It sounds easy enough, but still recommend going to an attorney and have them prepare it. So this is why I say you still want trust, even though you can do this very easy process, because if you don't know how to do it and you don't know how to fill out the form, you still have to go to one of the state probate court referees to get the property appraised to prove that the property is under 61,500. It's not just your affidavit that it's under 61.5. You have to get a probate referee that signs off on it. So again, my recommendation is go to an attorney. How much do we charge to get all this done? Because there's filing fees of, it's like $235. I think might have gone up, but just the filing fees, $235. The recording fee is going to be $150 depending on how much, because who knows? The state might increase that too. So you're already almost at like $500 in costs. And that's without an attorney. And then typically I charge about $600 to fill out the forms and get everything filed and get back that court order that allows you to take title to the property. So you're looking at $1,200 for a piece of property that might only be worth, if it's a vacant land in the middle of nowhere, it's possible. I have them happen all the time. Might only be worth a couple $1,000s. And so a lot of people look at it and go like, oh my gosh, why would I spend that much money for a piece of property that's worth so little? But usually I tell people, like, put it in a trust as part of your trust package while you're putting everything else in the trust. And then it's more economical depending on how much that property is worth, because now you can transfer all your properties through a trust for the fee of a trust. And the recording fee is, that recording cost. So, and then you avoid having to piecemeal and potentially spend 1,200, maybe 1,500 doing this court process. If your property is worth more than 61,500, but it's less than 184,500, you have to file what's called a petition for the order determining succession. Again, it's like a summary petition. You're going to recommend that you have an attorney do it because you got to file the paperwork. There is a court appearance, so it does take 2 to 3 months to get that court appearance. Once it's affirmed, then you get the judgment and you take that, it's like a court order, and you take that and you can record that court order. And that is good title that will allow that person to sell the property, and you guys can get through your transaction with your title insurance company. Okay. Now, always get questions about Prop 19, property tax reassessment. It always comes along, especially when I'm doing anything with estate planning. People are always asking, oh my gosh, can I transfer my property? My kids still get my property tax. Pretty much no. The only way is if it's your primary residence and your kids move into it, and only the children, right? It's like, that's the only ones that can qualify. So it's a very, very small exemption now. If there's any of you who've been around for a while, you remember before 2021, it used to be the entire value of your primary residence. Oh yeah, I forgot to say, there's $1 million cap now on your primary residence. And I haven't heard about them increasing that. But right now it's only up to $1 million in value can be transferred. Anything over, and the assessor's office can reassess the value over the $1 million. And that's on the primary residence. But if you remember, it used to be you could transfer the entire primary residence, regardless of whether the family moved it, the children moved into it or not, and regardless of the value of the house. So you could transfer a $10 million house to your children and they could rent it out, and their property tax would be the same as your property tax when you purchase the property. So now the state didn't like that because that robbed them of all those wonderful, glorious property tax. So we don't do that anymore. So now, and it used to be also your commercial property or any of your rental or second homes, you could also transfer to your children and they would get the same property tax assessment value as you had, up to $1 million worth of additional properties, secondary properties. We no longer have that since 2021. You can't do that. People always want to ask me, what are the workarounds? There aren't any anymore. At first, we thought there was going to be some workarounds, like, oh, I mean, technically, you could try that you, as the child, move into the house, claim the exemption, and then move out and rent it. But I got to tell you, tax assessors on to all those people. And if they find out that you've moved out and you're now renting that property, they will come back and they will find out when you moved out, and they will say you owe the back taxes for all of those years. Okay. What else can I say about Prop 19? It's good for the state. The state is now getting a lot more property tax. It's good for realtors because now the children want to sell their property because they don't want to have to deal with property and all of the increased property taxes when they're trying to have these secondary homes. So, but I am finding a lot of my clients, the children do want to move into their parents' houses because it's more affordable, because the property taxes are so low, and because the houses are usually paid off. And so they find that to be a great asset to them. So they keep the houses. Let's see. And I could also tell lots of other Prop 19 stories, horror stories about trying to do joint tenancy. Again, joint tenancy will mess up your property tax reassessments. All right. And always people are asking me, gosh, how do I get around the estate tax exemption? Well, gosh, you got to have more than $13.9 million in property. That's all your assets. And that's only the equity, right? So if you own $13 million, if you own a $13 million house, but you owe 10 million on it, you only have $3 million in taxable property. But if you only have $13 million when you die in assets, you will not pay anything in estate tax. If you go over that 13.9, we should all be so lucky to have that problem, then you might have to pay estate tax. So, but yeah, and that's per person. So married couple, do the math, right? You get to pass a lot of property. Okay. So it's now just a very rare time when I find somebody, have clients that are over that threshold. Now, this estate tax exemption is due to sunset or expire at the end of this year. And so it'll be part of the current federal government, their administration, to extend it if they want to. And from what we're all hearing is that they're going to extend this. So every year thereafter, so starting 2026, it'll most likely go up like each year again. So there's a whole schedule. So they pass it as a law, these estate tax exemptions, and they scale it out and they tell you each year how much it's going to be and when the law will expire. They have never made the law without a sunset, right? They've never passed it with a no sunset. They always have a sunset. They usually do it for, 5 to 10 years, depending on the administration. Okay. And I think that's my last slide. Hello. Is that my last slide? Yes. So we're ready for questions. So I hope that I've kind of gotten your mind going, and hopefully you haven't had too many horrific problems with transferring property for decedents. But I am more than happy to take your questions at this time. So
If you have any questions, please line up to the microphone because this is being recorded.
No, yeah, the closest person gets to ask the question first.
Hegstad.
Yes.
So parents had a trust, but it wasn't deeded into the trust. The children cannot find the original trust. All they have is a photocopy of the trust. Is that a problem?
That's good. It'll work.
It'll work. Okay, thank you.
So copies of trusts will work. Copies of wills will not. You must have an original will to go to court. You can have a copy of a trust. Another common problem that I'll see people say is like, oh, I've got property that's in a trust, but we can't find the trust. No worries. There's still a solution to that, but you have to go to court and the court has to create a trust for you. But you can do it. You can take care of it. So you don't need a copy of the trust. You just need the property titled in the trust, but it's preferable if you have the copy of the trust. Okay, yes, next.
Yeah, real quick, I have two questions. First one is, if I do a trust, do I need to do a will or do I need to do both?
You do both.
Okay,
So when I do a trust for a client, I do an entire trust package to be able to make sure that they have all the documents needed so that it can address any circumstance that comes up. I try my best. We can't be perfect, but I will do a trust, a certification of trust, a will, a power of attorney, an advanced healthcare directive, and then I also prepare the deed that gets recorded. So, yeah.
the second question, if there are two properties, each property has to do a trust?
So if there's more than one property, each deed has to be transferred into the name of the trust. So yes, you would do a deed for each property.
Okay.
The only time I think you can get away with one deed is if the properties are next to each other and you can put both APNs but and then all the legal description on one deed.
Okay,
But
thank you.
yeah, great.
Hi, Pro. I was just laughing at the hands. I was trying to figure out what color my hand is up there.
I'm being inclusive. What are you talking about?
That's
I
right.
know, right?
That's right. Absolutely.
It takes all
Um,
colors.
That's right. In the scenario of joint tenancy, you mentioned the son. Okay, so in the joint tenancy, when the son has joint tenant with the mom, and now he wants his portion, and now the girlfriend or the wife or somebody comes in, can the son enforce the sale of his portion, and where does the mother fall into that scenario? Thank
Right.
you.
Yes. So when you have joint tenancy and let's say it's between a parent and child, so we'll use the mother-son example that I have that I'm in litigation on right now. On that one, what it is the court or the son is suing in court to sell the property. When you put somebody on title, they now have the power to file a lawsuit and force the sale. So that's why you have to be very careful about who you put on title, because anytime you have co-tenancy, whether it's like a formal co-tenant or a joint tenant, they can force the sale of the property. It's called a petition for partition. And if you haven't heard of that before, look it up. And it's to me, it's super scary because now with this one, the mother is looking at having to sell her house because she cannot afford to refinance and get enough money to pay off the son for the share that he is demanding, right? So he's saying that he's entitled to 1/3 because he took title with his parents. And it was when his father died that he decided he needed the whole house, or not the whole, his third of the house, because now he's saying like, Dad died, Mom, you're still alive, but I need the money now. So, yeah, so he's claiming 1/3, and it can get really messy with joint tenancy because then it's about, well, what percentage, right? Because when you take title as joint tenants, you're literally saying I own the whole and so does this other person. We're both 100% owners. But when you sever that joint tenancy, or when you try to say like, no, I want my portion, it's going to be a percentage. Then you've got to sit there and navigate, like, how do you prove what percentage? So that's what we're struggling with right now, is trying to figure out what claim does he have to a certain percentage. He's claiming it's 1/3, but there's no documentation. There's no nothing. There's just parents thought this was going to be a great way to transfer the property on death. So,
Hi, bro. Thank you for being here. I got a
Yes.
few questions.
Sure.
First one, Prop 19.
Yes.
parent's primary residence, child moves in, is there a time limit that he has to stay there for how long before it gets reassessed? Or he has to stay there forever?
He has to stay there forever, otherwise it will get reassessed. The
Gotcha.
second he moves out, it's supposedly like it can be reassessed because
Okay.
he no longer lives there.
Okay. And
Yeah.
back to your slide, I think it was number 7. You said to file it correctly. What do you mean by that?
File correctly. Okay, let me see. Which slides are you talking about? Hold on.
7.
We'll go back. Okay, there's 6. No, that's 8. I don't even. So the trust, are you talking about in the trust filing?
Next page, but it might have been
Go back.
the piggy bank.
What's the piggy bank? The piggy bank.
Oh, sorry. 7.
This
This
one?
one, yeah.
Okay, so yes. So this one, it's what you want to make sure is you're doing everything correctly with an administration, because there's certain pitfalls that you can, it's always recommended that you have an attorney help you through with this, because when there's nothing to file in court, but there's receipts, waivers, and releases. And those are what you want to make sure you get, especially if you're the trustee. You want to make sure that you're getting all the beneficiaries to sign off that you did a good job, and they're not going to come back and sue you and say you didn't give them all of the money that they were entitled to out of the trust. So from time to time, I have that happen. So you want to make sure that your beneficiaries, when you distribute the money, that they sign off that they received the money, and that they signed off saying that they acknowledge that's all they're going to get, and they're not going to come back against you for anything more. So that's a release. It's a release of liability of the trustee. Okay.
Hi,
Next.
I have a question regarding putting the foreign assets into a living trust. I know we cannot put the foreign assets into U.S. living trust.
Yeah.
But is there any way that we can transfer foreign assets?
Right. So typically what I tell my clients with assets out of either out of the state, well, not so much out of the state, but out of the country, right? So let's say you have assets in China or assets in Mexico. I recommend that you go to an attorney in those countries and ask them, how do you transfer property on death? Because it's not going to necessarily be the same as our laws here in the state of California. So sometimes they can do they can transfer title of the foreign asset into a U.S. Created trust, but sometimes they can't, and you have to do a separate whatever in that country. I don't know, because I don't practice law in those other countries. Another thing to note while we're going along the lines of foreign assets is that tax exemption amount is only for U.S. citizens. So if you're not a U.S. citizen, you do not get a federal estate tax exemption. So it's much different. So, and especially when your beneficiaries are foreign nationals, like they're not U.S. residents, and you're trying to ship out money, government doesn't like that. They want to tax you. And the place where you live might tax you also for inheriting that money. So that's the pitfall of dealing with other countries and their laws regarding inheritance taxes. Yes. All right, next question.
Hi, thanks for coming.
Yes.
I have 2 questions. The first question is, a couple married with children, and then they purchase a property under only the husband's name. So if the husband passed away, so what, is the property goes to the wife?
Yes. So the wife can claim the property because it's purchased during marriage, even though it's only in the husband's name.
Mhm,
She can file with that spousal property petition,
mhm.
that summary petition, and claim it as community property, that it's all hers.
So
And the court
all
will,
hers?
yes.
Not 1/3?
No,
Oh,
because it's purchased during marriage,
mhm,
it's community property. Now, if there's some claim that the husband uses separate property funds to purchase that property and purchases it as a separate property asset, and there's proof,
Mhm.
then it could be that the children can claim, oh, that's a separate property asset. And then they can object to the mother claiming it as a community property asset. But for the most part, if you are purchasing property during marriage, it's presumed to be community property.
Even they marry with children.
Married with
No.
children, you're purchasing property, doesn't matter how you title it. If you're married, your spouse can claim it.
And
Same with your, like any of your pensions or IRA accounts that you try to set up and you want to name a beneficiary other than your surviving spouse, you're gonna have problems because you made that money during marriage that you put into that pension or 401k. Spouse will have a presumptive ownership interest in it because they are entitled to their community property, half of their income.
even though the kids doesn't, they don't get along with the wife or something, it's fine, right?
Marriage is a very strong bond in the state of
Okay.
California.
Alright. Okay,
Marriage gives you a lot of power and authority over assets.
okay. My second question is, you're talking about parents to children.
Yeah.
How about uncles to nephew?
Yes. Again, this is all about what kind of assets do you have and what are your gifts that you're going to make. So it's always recommended, especially if you own real property and you don't have children and you want to have something in writing as to what your instructions are for what you want done with your assets when you pass away, because the law has presumptions in it. They have like a default that says, oh, okay, you don't have any children, you're not married. Okay, this is how we're going to give out your property when you pass away. So if you have some other idea or some specific idea of what you want to do, you better get it down in writing, because that's going to be what controls what happens to your assets on death.
So the nephews, they are going to tax-free? Oh. Okay, so the nephews, okay, or the niece, okay, they are going to get tax-free, right? They don't.
So yeah,
exemption.
so it depends. So let's say somebody passes away, they don't have a surviving spouse, they don't have children.
Mhm.
So what the courts do is they say, okay, and there's no will, there's no trust. So the courts are gonna look to, did that person still have living parents? If there's a living parent, it goes to the living parent. If there's no living parents, we're gonna look to see if that decedent had any surviving siblings. So we look up we're looking up the family tree. And if there's no surviving siblings, we're gonna look to see if the siblings had any surviving children, nieces and nephews, and they'll take equally on that level.
So
Okay.
he cannot designate or, assign to
If-
anyone.
He can, but
Okay.
he's got to do a will or a trust or something in writing, right?
Okay,
Because if he just verbally says it, it doesn't mean anything.
all right.
He's got to put it down on paper.
Okay.
So it's most definitely recommended that you do a trust if you own real property and you don't have children and you don't have a spouse. You want to make sure you have something in writing as to what your specific intentions are.
Okay, thanks so much.
Uh-huh.
Thanks for all the great information,
Yes.
April. And I just wonder how much do we charge for doing a living trust?
Okay, so right now, even with the price of eggs, I'm still only charging $1,800 for a single person who does a trust with one piece of real property. We go up $200 per piece of property. That in addition that needs to be recorded. For a married couple, I start at $2,200 for the married couple with one piece of property. And again, you add $200 for each additional deed that needs to be done for each additional property.
Okay, let's say I have a living trust, which is more than 10 years old, and I just want to do an update on it. And how much do you charge?
Okay, so for amendments, $300.
Just for amendment?
Just
$300.
amendment. Yes,
Thank you.
yes. Uh-huh. All right.
Thank you for all your information. So I heard that the property tax, if someone die with a trust, then there will be no step up of the property tax.
No, it's no step up in the capital gain. the step up in cost basis. So I think you're mixing the two. So there's a capital gains, right? So capital gains is whenever you sell real property or sell an asset, there's a difference between what you purchased it at and what you sold it at. And if the value of the asset goes up, so let's say you buy a piece of real property for 100,000 and you sell it 1 million, you've got 900,000 in capital gains tax or
Yes.
capital gains, and you pay tax on it. If the person passes away and it transfers on death, it's because of that estate tax exemption law. In that law is, okay, we might tax you for an estate tax, but we're going to give you no capital gains tax. So everything steps up in value. So your cost basis becomes your date of death value on anything that you've inherited. So let's say mom and dad purchased a property for 100,000. 30 years later, they die. It's $1 million. They leave it to the kids. The kids, their cost basis is 1 million. So if they go out and sell the property the next day and they sell it for $1 million, they have no capital gains. If they wait a couple years and they sell it for 1.2 million, they have 200,000 in capital gains, even though their parents only paid 100,000 for the house.
Is trust the only way to avoid the stepping up?
No.
No?
It happens regardless of whether you have a trust. Your
Oh.
cost basis will step up on death.
So no
So that-
matter it's a will or you just file like the death process, or you have a trust, it's the
Right.
same, all get the step up.
Everybody gets a step up in cost basis that inherits property or assets, any assets. Yeah. So you inherit stock. Let's say you inherit, your parents' Disney stock or whatever. And now, they bought it for 10,000 and now it's worth $1 million.
All step up.
It steps up the cost basis. So when you inherit at zero capital gain, right?
But the property tax,
The property
you
tax,
pay every year. The kid has to move in and live there forever to get.
to keep the same property tax, what I call inherit the property tax.
Okay,
Yeah.
or else they will have to do revalue of the
Right, they do a
property then.
reassessment, yes.
Okay.
The assessor's office, right, Jeffrey Prang's office comes in, reassesses. And yeah, and
Okay,
it
thank
can,
you.
yeah. And that can get scary for a lot of people real quick. But yeah, it'll get reassessed because reassessment occurs every time there's a change in ownership of 50% or more for real property. Okay.
Question, it sounds like even with the first time home buyer, is there a economical way that we can, instead of just pointing them to the list of possible ways to take title, an economical way to have them consult with somebody if
Right.
they're planning?
So I always give a free 1-hour consult to any clients so that I can go over their options with them.
Thank you.
Yes. So I hope a lot of attorneys do that. I know I do, but that most attorneys should do at least a free 1-hour consult to help people figure out which one they need.
About the step up, like a benefit you just mentioned,
Yes.
is that also apply to foreign people? For example, if foreign couple, they purchase a property, they probably don't, right?
It's U.S. citizens,
I see. Okay, thank you.
right? That law
So-
applies to U.S. citizens.
So if for foreign couple, for example, and one person passed away, what it going? So they still based on the
They're going to
original
go see a
purchase?
CPA.
Okay, got you. Thank you.
Right? And that's basically code for you're going to be paying taxes. Yes. Oh, the law, does the tax exemption apply to U.S. residents? Yes. Green card holders? Yes. It's just foreign nationals who don't have residency. Right? Visa holders do not qualify. So if you're a visa holder, you can't get the tax exemption.
Okay, let's give April a hand, please.
Yeah.
A lot of
we're over
information.
time.
West San Gabriel would like to thank April for spending your time here and giving you a lot of information, which I hope it's helpful for everyone. And as part of, for April Verlato, we like to thank her and give her a certificate as part of the Education Committee. And again, let's give April a hand. April's information is there. Please take a picture and you reach out to April with any other questions.